exemption to the conduct of preliminary investigation, or 4 to 1 and up, when the respondent is arrested in flagrante delicto, wherein the person is actually committing or attempting to commit the crime, or the person to be arrested is actually committing or attempting to commit a crime. So that is flagrante delicto, no need for preliminary investigation, only undergo a inquest proceeding. So again, what's a inquest proceeding? There are two types of warrantless arrest to have inquest proceedings. First, it's the flagrante delicto arrest, and the other one, it's the probable cause arrest or hot pursuit arrest. In flagrante delicto, again, in the presence of a person, when in his presence of peace officer or any person, the person to be arrested has actually committed or actually committing or attempting to commit an offense. While a probable cause arrest or hot pursuit arrest, wherein the offense has just committed, and the peace officer or person to arrest has probable cause, or the person has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. So these two situations shall undergo a inquest proceeding in flagrante delicto arrest and the probable cause arrest or hot pursuit arrest. In inquest proceedings, it will be conducted by the inquest prosecutor. What if there is no inquest prosecutor? So the complaint will be filed immediately directly to the court. Can the accused ask for preliminary investigation after warrantless arrest? Yes, he can, but he must execute a waiver of Article 125 under revised penal code in the presence of his counsel. If you are wondering what is this Article 125 of the revised penal code, it is the delay in the delivery of detained person to the proper judicial authorities. It contemplates a valid warrantless arrest in which the offender here is a public officer, particularly the policeman or employee, and such person detained another person for some legal grounds, and detaining him and fails to deliver such person to the proper judicial authorities within period stated, 12 hours for offense punishable by light penalties, within 18 hours for offense punishable by correctional penalties, and 36 hours for offense punishable by afflicted penalties. If such that offender failed to deliver the detainee to the proper judicial authorities within the specified period 12, 18, 36, therefore he should be liable under Article 125, that is arbitrary detention. The delivery here means it's the filing of correct information or complaint in the proper judicial authorities. It is not the actual turnover of person to the court. No, it's not. It's the proper filing of information or complaint. And the proper judicial authority refers here are the judges vested with judicial power to order temporary detention or confinement of a person charged with having committed public offenses. Prosecutors are not proper judicial authority because they do not have the power to order temporary detention. So, under Article 125, the proper judicial authority refers only to judges and justices who has the power to order the detention of a person. The prosecutor has no power to order detention, so he is not considered, or he is not one of those with the proper judicial authorities. What is the effect if the information is filed beyond the specified period? Baga lampas na. The information was filed beyond 12 hours for light penalties, beyond 18 hours for correctional penalties, or beyond 36 hours punishable by afflicted penalties. So the effect would be the filing of information in court beyond the specified period does not cure illegality of detention. Hence, detaining officer is still liable under Article 125. Neither does it affect the legality of confinement under process issued by the court. So, it means to say, if there is beyond filing of information, beyond the specified period as stated by the law, the detaining officer, the police, and such employee will be held under Article 125, the arbitrary detention. To further understand that an inquest proceeding is an investigation conducted by a prosecutor in criminal cases where a person has been lawfully arrested and detained without the benefit of warrant. So, this is a warrantless arrest. So, determine the purpose of inquest proceeding is to determine whether the arrested person was arrested lawfully in accordance with Section 5, Paragraph A and Paragraph B of Rule 113, that is already the flagrante delicto arrest and the hot pursuit arrest. If they are lawfully arrested, the accused may ask the arrested person. The prosecutor may ask the arrested person if he wants to avail his right of preliminary investigation. So he may ask with the waiver of Article 125. Again, Article 125, it's the arbitrary detention with 12, 18, 36 hours of detention beyond filing of correct information to the proper judicial authorities. Therefore, it will make the detaining officer liable under Article 125. If the result of the inquest proceeding, says that the arrest is illegal, the prosecutor shall not proceed with the inquest and recommend the release of the arrested person, which recommendation should be approved by the head. So, if he finds, if the resolution of the inquest prosecutor is the arrest is illegal, immediate release of the accused with approval of the head. If the arrest is found to be legal, he shall proceed with the inquest, and if he finds probable cause, an information will be filed. So again, if the inquest prosecutor finds that the arrest is illegal, he will not anymore continue with the inquest proceeding. He will make an immediate release of the accused. But if the arrest is legal, then he will proceed with the inquest and determine if there is probable cause to file an information in court. Question: can the accused appeal the resolution of the inquest prosecutor's finding of probable cause to the Secretary of Justice? Again, can the accused make an appeal to the resolution of the inquest prosecutor of finding probable cause to the Secretary of Justice? The answer is no. The Supreme Court held already in Leviste versus Alameda wherein the remedy of appeal to the Secretary of Justice is not immediately available in cases subject to inquest. So, appeal the decision of the inquest prosecutor to the SO, the Secretary of Justice, is not available, is not immediately available. The proper would be the private party should first avail of a preliminary investigation or reinvestigation, if any, before elevating the matter to the Secretary of Justice. So, again, the accused cannot make a appeal to the Secretary of Justice if he is undergoing an inquest proceeding, or if he gone under an inquest proceeding and finding him probable cause. He should first avail the preliminary investigation, and the resolution of that preliminary investigation is appealable already to the Secretary of Justice. This time, Rule 113, arrest. The taking of a person into custody in order that he may be bound to answer for the commission of an offense. That's the definition of arrest. It's the taking of person into the custody to answer questions in relation to the commission of an offense. How is arrest? So, how is arrest made? Very simple. It's just the actual restraint. So, of a person to be arrested, using the handcuff, getting him to the mobile, bring him to the police station. That's the actual restraint. Or by his submission to the custody of the person making the arrest. So just simply going to the police station, admitting his guilt, that he is the killer, he is the accused. Provided that in arrest, there must be no violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subject to a greater restraint than is necessary for his detention. So only enough force to restrain a person. Except in some cases wherein there is already violence manifested by the accused, there is already a force needed to restrain him, to execute the warrant, to execute the order of the court. Penalty of fine only, no need arrest. The failure to wear a crash helmet while riding a motorcycle is penalized by a fine only. Thus, the motorist's detention due to traffic violations cannot be considered as custodial interrogation or formal arrest. That is already held under Luz versus People. So, just if the penalty stated by the law is fine only, there is no arrest. There can be no custodial investigation be made against him. Requisites for the issuance of warrant of arrest. Under our Constitution, particularly in Section 2 of Article 3, that is our Bill of Rights, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. So there can be no, for any other purpose, there can be no deprivation, there can be no oppression of persons, houses, papers, effects, against searches and seizures. It cannot be violated. It shall be inviolable for any purpose, and no search warrant or warrant of arrest shall be issued against them, except this exemption, except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. As a general rule, persons, houses, papers is protected from any unreasonable searches and seizures. But if there is probable cause determined by the judge personally by himself after an examination, under oath or affirmation of the complainant and the witnesses he may produce, thus describing the place to be searched, therefore persons, houses can be searched lawfully. Probable cause to be determined personally by the judge. It's a personal examination of complainant and witnesses is not required. It's the personal examination. It's not required. Okay, judge is only required to examine the records of the case to determine probable cause for issuance of warrant of arrest. So, personal determination by the judge does not mean the personal examination of complainant and witnesses. No, it's not an actual, it's not literally that he will interview the complainant and the witnesses. It is by examining the record filed in his sala. That is how he will determine if there is probable cause. That is under Sullivan versus Macassiar. If the judge finds probable cause, he will issue a warrant of arrest and forward it to the police station. Then the police station will make an arrest at any day or at any time of the day or night. Then it shall execute the warrant of arrest within 10 days from receipt of warrant. After that, after the expiration of the period, it will make a report to the judge who issued the warrant. In case of failure to execute the warrant, they shall state the reason why. Take note that the warrant of arrest is valid until the arrest of the accused. So even it occurs them 1 year to arrest the accused, the warrant of arrest still valid for 1 year. It will be valid until the arrest of the accused. The report on warrant of arrest shall only mean a report and will not affect the validity of the warrant of arrest. Still, the warrant of arrest is valid even the lapse of 10 calendar days from the issuance of the warrant of arrest. The court then, after the report, shall issue alias warrant already. So, after 10 days, after 10 calendar days, it will already issue an alias warrant. Note again that the 10 days effectivity of warrant is subject to search warrant and not warrant of arrest. Thus, warrant of arrest is valid until the arrest of the accused, and the search warrant is valid only for 10 calendar days from its receipt. So, for short, the warrant of arrest is valid until the arrest of the accused. A warrant of arrest is valid until the arrest of the accused. But search warrant is only valid for 10 calendar days from its receipt. This time, let's go to warrantless arrest. The lawful arrest without the benefit of warrant. Under Section 5, Rule 113, a peace officer or private person may, without warrant, arrest a person and subject to inquest proceedings in flagrante delicto, arrest, and next is probable cause arrest or hot pursuit arrest, and the third one is arrest of escapee. In the first, flagrante delicto, as we are keep on repeating it should be in the presence of that peace officer or any private person. The person to be arrested has committed or is actually committing, so still committing, or is attempting to commit an offense. The very important here is that the person to be arrested must execute an overt act. So it's clear, very clear. He's committing an illegal act, indicating that he has just committed or is actually committing or is attempting to commit a crime. So there should be an overt act. There is a manifestation. There is a clear manifestation, a situation that he is about to commit or is attempting to commit or already committed. And the overt act is related to the crime which the accused is to be arrested. The overt act is accompanied by reasonable suspicion must actually seen by the arresting officer. So it should be seen there. There should be circumstances, the situation. It's very clear to the situation. There are blood, certain blood, the knife, circumstances that leading to the accused that there is a crime committed, the dead body. It's very clear. It should be very clear. And it should be in the presence or within the view of the arresting officer or private person. So it should be clear. There is an act, there is an overt act, and the overt act is related to the crime committed. To have a clear picture about overt act, let us have these examples. Rebellion versus people. The arresting officer witnesses the accused handling a piece of plastic sachet to his companion. That is an overt act, wherein the witness have seen that the accused is giving a piece of sachet to his companion. Binibigay niya. Actually, nakita ng witness that the accused is giving, handling a sachet to his companion. So that act is already considered an overt act because it was seen by the accused. The handling, the act of handling is an overt act. Arousing suspicion, the officers alighted from their vehicle and approached the accused. They found the accused holding 3 strips of aluminum foil and sachets of alleged shabu. Next, People versus Pabia. A tip from a concerned citizen reached the police station that pot session was taking place in the house of the alleged accused. They went to the place and through a small opening in the window, they were able to see accused sniffing shabu. So, the police officer acting on a tip and as arriving the place, they have seen the act of sniffing shabu by the accused. Then therefore, the act of sniffing the shabu is an overt act. Next, People versus Valdez. Accused was merely seen by an officer. Accused was merely seen by an officer as looking around after getting off the bus and attempted to run away when Tanod approached him. So, there is a suspicion act. When Tanod approached him, the accused immediately ran away. So, the running away or attempting to run away is an overt act. Next, People versus Claudio. Accused was carrying woven burr-like plastic bag with what appears as kamote. But instead of placing bag besides him, he placed it at the back. Narcotic agent checked the bag where marijuana smell emanates. To dissect, there has been a suspicion on the officer when the accused was placed his bag at the back. That is an overt act already. So the act of placing the bag at the back, of hiding the bag from the officer is already an overt act. Overt act that is plain to the view of the arresting officer. The second one is the probable cause arrest or hot pursuit arrest. It is when offense has just been committed and he has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it. So the peace officer or the private person has the personal knowledge of facts and circumstances that the person to be arrested has committed the crime. So here, the arresting officer, the arresting person, does not actually see the crime. They did not see the crime. Otherwise, it will fall under in flagrante delicto. So the requisites here to be valid is that an offense has just been committed. So tapos na. Has just been committed. There must be urgency to catch the perpetrators or the accused because an offense has just been committed. If there is a lapse of appreciable time between the commission of the crime and the arrest shall be invalid, and the proper remedy secure is warrant of arrest to court. So here, once there is already a personal knowledge that the crime has been committed, there is already an urgent that needs to arrest the accused. Next is that the person making the arrest has personal knowledge. So that officer did not even see it, but based on his personal knowledge, he has a personal knowledge that the crime has been committed based on facts and circumstances. This is the probable cause requirement. Stated otherwise, the person making the arrest has probable cause that the accused is the one committed the crime. So it should be a well-founded belief based on the personal knowledge that the crime has been committed, just only seeing from the circumstances, from facts around him. Next is that arrest solely on a tip, giving him a tip from a concerned citizen, is not a personal knowledge. These are some cases of hot pursuit. In People versus Acol, when a policeman immediately responded to the report of the crime, the victim points the accused and the police run after them. The personal knowledge is established when the police is at the moment the victim points the accused. In another case, People versus Tonon Jr., the arrest was done on the same day was held valid. In the case, the arresting officer had knowledge of facts which he personally gathered in the course of his investigation, indicating that the accused was one of the perpetrators. These are also cases where hot pursuit is not appreciated. Posadas versus Ombudsman. The killing happened on December 8, 1994. It was only on December 11, 1994 that Posadas requested the NBI assistance. NBI attempted to arrest the accused 3 days after the commission of the crime. Thus, the arrest was invalid because there is a lapse of time from the offense to the arrest. It cannot be said that the officers had personal knowledge of the facts. So from the previous case, if we will compare this Posadas versus Ombudsman to People versus Tonon Jr., in Tonon Jr., the arrest officer arrest the accused on the same day. It's valid based on his investigation. While in Posadas Ombudsman, there is a lapse of 3 days. Lapse of 3 days from the time the offense to the arrest. So therefore, it cannot be said that the officers have personal knowledge of the facts. People versus Del Rosario. The requirement that an offense has just been committed means that there must be a large measure of immediacy between the time the offense was committed and the time of arrest. If there was an appreciable lapse of time, a warrant of arrest must be secured. Thus, Rolito Go versus CA, the arrest of the accused 6 days after the commission of crime was held invalid because the crime had not just been committed. So, here, in hot pursuit arrest, there must be a large measure of immediacy, as in People versus Del Rosario. Large measure of immediacy between the time the offense was committed and the time of arrest. For short, there must be a sense of urgency, immediacy. Otherwise, if there is lapse of time occurring more time from the time of commission of the offense to the time of arrest, there is already a need to secure a warrant of arrest. The last for warrantless arrest is the arrest of escapee. When the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. So therefore, there is a warrantless arrest that can be made. Rights of the accused: to be assisted by counsel at all times, to remain silent, to be informed of the above rights. The Miranda rights: right to remain in silence, whatever you talk, it shall be used against you. You have the right to have your counsel at your own choice. If you cannot avail one, the state will grant you one. That's the Miranda rights. Next is to be assisted by the immediate members of the family, by his counsel, or by non-government organization, whether national or international. Those are the rights of the accused. These are the things to remember when it comes with illegality of arrest. Illegal arrest if there is invalid warrant of arrest and invalid warrantless arrest. The effect is that on the jurisdiction of the court. The court cannot acquire jurisdiction over the person of the accused, so it cannot hear and try the case of that accused. But the illegality of the arrest cannot be the basis for acquittal. That is People versus Yao. So again, the illegality of the arrest only affects the jurisdiction of the court. It does not acquire properly jurisdiction over the person of the accused, and at the same time, but it cannot be the basis for acquittal of the accused. It will not negate the validity of the conviction of the accused, as in Rebellion versus People. So the illegality of arrest does not affect the validity of conviction of the accused. The last thing for arrest is that the application for admission to bail shall not bar the accused from challenging the validity of his arrest or legality of the warrant issued, provided he raises his objection before he enters his plea or before arraignment. So here, the application for bail does not bar him, does not stop the accused from challenging the validity of his arrest or the legality of the warrant issued against him. So it will never affect the validity, provided he raised his objection before entering his plea or before entering arraignment. So again, the application for bail does not stop him from questioning the legality, validity of the warrant or his arrest, provided he will raise it before arraignment. Posting of bail is not a waiver of challenging the legality of his arrest. Accused can only question the legality of his arrest before he enters arraignment or before he enters his plea. Otherwise, he waives it. He waives the right to question the legality of his arrest. So, once the accused failed to raise the legality, the validity of his arrest, he is already waiving the right. So, he cannot anymore question it after arraignment, after he makes already his plea. However, waiver of illegality of arrest does not extend to evidence obtained as a result of illegal arrest. Thus, evidence obtained in illegal arrest are inadmissible. So this is very important. The waiver of arrest does not affect or does not extend, does not cover the evidence presented, the evidence obtained as a result of illegal arrest. So all those pieces of evidence, obtained, collected during an illegal arrest are considered inadmissible as evidence in court. Example, X was illegally arrested and a sachet of shabu was confiscated. X was charged of a crime of possession of illegal drugs. During arraignment, X does not file a motion to quash on the ground of illegal arrest. On the trial, prosecution is now offering sachet of shabu as object evidence. X's counsel objected that the sachet of shabu is a fruit of poisonous tree because it is a product of illegal arrest, hence inadmissible. So the counsel is correct. Object the introduction of sachet of shabu as evidence because that sachet of shabu was obtained during an illegal arrest. Then such sachet of shabu is a fruit of the poisonous tree because it is the fruit from an illegal arrest. And therefore, it is inadmissible as evidence in court.